Right. As I mentioned when we open the meeting, I'm going to start a minute or two early here, just because we have a lot to cover. So I'm going to start by introducing today's presenters. Monica Balafutis, Senior Director of Wealth and Trust Investments, has been with Orrstown Bank for 17 years and oversees our wealth and trust investment management operations, fiduciary, and compliance areas. Andrew Reith, Wealth and Trust Portfolio Manager, has 15 years of industry experience and oversees investment strategy and client portfolios. Both Andy and Monica have obtained certifications in the investment and financial industry, most notably the Chartered Financial Analyst designation, or CFA. Just want to note here that this presentation is not intended to provide specific legal advice on any particular matter. Instead, it's designed to provide general information which we hope will be of interest and helpful to you. Please consult your attorney with any questions about your specific situation. And with that, I will kick it over to Monica.
Thank you, Chris. Who knew talking about death would draw such a crowd? I think this might be our highest attended webinar so far. Well, just a little bit here about Orrstown Bank's Wealth Management Group. We do have over 50 employees who have been helping clients plan, manage, and meet their financial goals for almost 4 decades now. So our teams of experienced professionals are located across our footprint in Pennsylvania and Maryland, but we assist clients across the United States and at all different stages of their life reach their financial objectives. So what we offer here is just a little bit of an example: financial planning, investment management for individuals, businesses, institutions, and many of our local organizations and nonprofits, as well as retirement accounts such as 401k rollovers and IRAs, trust services, and estate planning and settlement. So if you're new here with us today, if this is the first session you're with us, no worries. This is a 4-part series, and this is number 4, but they also can be handled as standalone webinars. So in the first webinar, we did cover the first 2 columns here: financial habits and saving and investing. And then we dove into the planning side, starting with our overarching financial planning. And then we went a little bit deeper into retirement planning. And here today, it's legacy and estate planning. So just getting a definition right off the bat, an estate is simply a legal entity that is created when a person dies. So what we're going to be talking about today is things that we need to get in order to prepare for that eventual death that will come for all of us. So we want to make sure that we make that process of settling an estate for your heirs as simple as possible. Sometimes this can be a very overwhelming planning process for people. It can be emotional, and they don't know where to start. Here's just some simple questions you should try to see if you can answer in terms of: who do you want to leave your assets to? Is it individuals? Are there charities or organizations that you want to leave assets to, or maybe both? What do those assets look like? We talked about this during the financial planning piece as well, kind of identifying your assets. The financial plan will help you do that. But do you have real estate to pass down? Do you have any business interests that you might need to do some succession planning on? Investments, personal items, things of that nature. And then when? Do you want a gift during your lifetime or at the time of your passing? Or maybe it's both. And then there's the how. Do you want to place any restrictions on anything? Give certain amounts to people, but they only obtain it at certain ages? Things along those lines. So the goal here with estate planning is trying to take some burden off of your loved ones who are already dealing with the loss of a family member or something. So we want to try and simplify it for them. We often think that estate plans are for after death, but there are benefits to having an estate plan during your lifetime as well. In the bluish and green bars, there's a bunch of bullet points listed there. I'll just kind of summarize this. But ultimately, during your life, having some of that estate plan already in place, if something were to happen to you, let's say you cannot make your own choices and decisions on yourself, that plan will start to step in and help your heirs with that. It also will allow you to figure out, can I gift now? Should I gift later? Maybe you want to enjoy seeing your heirs and other charities benefit from the assets that you give them during your lifetime. We also can work on mitigating taxes and navigating any complex situations while you're still around. And then in the orange, upon death, the ultimate goal is to make sure that your wishes stay intact and that your assets are distributed in a timely manner. We want to try to avoid getting messy court cases and stuff occurring here. So by having a well-executed plan set in place, hopefully we can avoid that. I will provide a little bit of an example, and I got permission from our financial advisor. This is a personal story from one of our advisors. Her father had passed away, and within 2 hours or in the same day, her father-in-law also passed away. Now, she was the executor of her father's estate, and her husband was the executor of his father's estate. So they were trying to settle two estates at the same time. The caveat here is that her family were very open about their financial situation. They had done financial planning, they had shared it with their children. Their children were aware of what they owned, what would happen at the time of their passing, and she had that financial plan as her roadmap to settle that estate. On the other hand, her husband's family never spoke about their financial situation. He didn't know what accounts they had, where they had them, insurance policies, or any of that. Now, she was able to settle her father's estate in about 4 months, whereas her husband's father's estate took about 2 years, and had accounts all over the place that they needed to locate. So certainly at the time of your passing, the last thing you want to do is put that additional burden on your children or loved ones, whoever's settling your estate. The more guidance you can provide them while you're living, the better for them when you're no longer here. I won't go through all of this information here. You will get the replay, but this is a great starting point to try and take inventory, gather some of the items and documents that you may need. In this advisor's example, they had a binder that had everything that they needed, including usernames, passwords, all that kind of stuff. So certainly consider starting to gather information. 3 legal documents everyone should have. One would be your general durable power of attorney. This is your financial power of attorney. You should also have a durable healthcare power of attorney and a living will. So this will be for medical reasons. And then, of course, a last will and testament as well. So I'm going to dive into these a little bit here at a high level. So your general durable power of attorney, this is the person that you are going to appoint to help answer any financial matters or take care of any financial matters while you're still living. This is only in effect during your lifetime, but if you are at the point where you are not able to handle your own finances, this is where this person would step in. We often think of it as this is the person who's handling your bill paying and other financial transactions, who's filing your taxes, if you are not able to do it on your own. In terms of who can serve as agent, from an individual standpoint, you could have a family member or a friend, but you could also have a corporate power of attorney. So this could be a bank or a trust company. For example, Orrstown Bank's trust department or a wealth management department, we act as power of attorney from a financial standpoint for clients, or we're listed in their documents to be in case that they are unable. And ultimately, the duty of this agent is to act in the principal's best interest for their benefit and handle their financial matters. From a medical standpoint, this is typically going to be an individual that you are assigning to handle any healthcare decisions for when you are not able to. Along with that power of attorney, typically is going to be a living will, and this is where it will kind of provide information to that power of attorney on how you want your medical treatment to occur when you are at the point where you cannot do this. So think when you're incompetent or at the end stages of some kind of medical condition or state of permanent unconsciousness. This is when that person will step in. So a living will kind of helps guide them in making those decisions along with your wishes. Now I'm going to hand this over to Andy. He is going to, I kind of covered, prior to death. Andy is now going to switch over to what will happen after death when your last will and testament comes into play.
Yeah, I drew the short straw, so I get after death. So a will or a last will and testament is a legal document that dictates how you want your assets distributed and who you want to care for your dependents after you pass away. Some notable individuals that passed away without a will include Abraham Lincoln, Picasso, Bob Marley, and Prince. Now, these individuals had sizable assets that needed to be distributed, and there was a lot of angst amongst their family, and legal battles drew out for multiple years. Now, if you're like me or the general public with less assets, you still need a will. It's still important to specify how you want those assets to be distributed on your terms. Because in Pennsylvania, when someone dies without a valid will, it's considered intestate. So state law dictates how your property will be distributed, and the estate passes to surviving relatives in a strict hierarchy based on law. So if you are a surviving spouse and you don't have any children or parents, your estate passes to the spouse. It's pretty straightforward. But then if you are married and have children, the spouse receives the first 30,000 plus half of the remainder, and then your children receive the rest. Now, PA law, that might not seem like a big deal, but if you have minor children, their assets could go into a guardianship account, and they might not be able to touch that till they turn 18. So your spouse doesn't necessarily have the discretion on how those assets will be used, and it might not be what you want. You might want your spouse to have control of those assets until they pass. Or if you have a spouse and parents, but you don't have any children, again, the spouse is going to receive the first 30,000 plus half of the remainder, and then the parents receive the balance. And then if you die without a spouse, assets pass to the nearest living relatives in a specific order, which would go first to your children, then your parents, siblings, grandparents, and so forth. So it's important to have a will to specify what you want. So how do you get a will and what's contained in it? So you should have a qualified attorney draft a will. And depending on your circumstances, you may need a specialized attorney to draft specific needs. And we'll get into that in a little bit. So cash or specific bequests to individuals and charities are outlined in your will. So set dollar amounts, or if you have collectibles, you have a Mickey Mantle baseball card that you want passed to somebody specifically, you would have that outlined in your will. You can also create trusts for beneficiaries who may need assistance or protection. We mentioned the minor children that has assets put into there, specifying for their health care, their education, or just their general well-being. Disabled persons that need different terms specified, or individuals that have suffered from substance abuse and you don't want assets distributed to them outright in a large lump sum. Spendthrifts, could also similar, so that lump sum is not distributed to them directly. Basically, money can be trickled out to them, or requests for healthcare needs, education, or shelter costs can be paid directly and not distributed to that beneficiary through their hands. Then individuals and or charities that you want to receive the rest of your estate is spelled out within your will. And then ultimately, you're going to name your executor. Now, it's an important decision because there's a lot of responsibilities for the executor to administer an estate. So on the next slide, at a high level, the executor is going to probate the will at the local courthouse. This is the legal process of validating a will. So they're going to take the original will, death certificate, and a petition for probate to validate that will. Once it's validated, they'll receive a short certificate, which gives them the authority to be the executor, gives them the authority to close out accounts, to start to collect, liquidate, and distribute assets of the estate. They're also going to pay debts and pay taxes on the estate. And then they also will make the distribution to beneficiaries. So that's a high level breakdown of what they're going to do. But on the next couple slides, we'll kind of get into a more granular level. A lot of responsibilities here. So they're going to provide notification to the beneficiaries. So this is a notice of probate or notice to beneficiaries that usually occurs in the first 30 to 90 days after a decedent passes away. They're going to obtain a federal tax identification number. So they're going to have to apply on the IRS website or fill out an SS4 and submit it to the IRS. They have to advertise the estate. So there's going to be a posting in a local newspaper for probate and creditor notification. Then they're going to have to value estate assets. So back to the collectibles, depending on what assets you have, they're going to need to be valued. Cash and securities, tradable securities, the date of death valuations are pretty straightforward. But then if you have real estate, Monica mentioned about valuing real estate, vehicles or private business interests would have to be valued by a CPA. Now, depending on what the will specifies as far as the distribution of those assets, you may need to liquidate. So the valuing and the liquidating of assets could require hiring experts in those fields, depending on what type of assets that you're dealing with. Then you're going to have to correspond with the PA Department of Human Services. And then we're going to get into a bunch of tax filings. So you want to name an executor that loves to file taxes. So they're going to file a final lifetime income tax return, and then they're also going to file fiduciary income tax return for the estate. And the list goes on. So I mentioned that you want an executor that loves to file taxes. You're going to prepare and file Pennsylvania inheritance tax return, and then you may need to file a federal estate tax return depending on the size of your estate. Now, even if your estate's not large, you may still want to file a federal estate tax return for portability purposes. Now, portability is due to the federal estate tax exemption. So each individual has 15 million in an exemption available to them. And then that's any remaining is portable to a surviving spouse. So if the first spouse that passes away utilizes 5 million, they have 10 million remaining, and that would pass to the surviving spouse, which started with 15 million, now has an extra 10 available to them to exclude from federal estate taxes. So they can exclude a total of 25 million in federal estate tax assets in their calculation. So in addition to that, they're going to prepare and file an inventory with the Register of Wills that involves compiling a comprehensive itemized list of assets solely owned by the decedent at the time of death, along with their date of death values. This document's filed typically within 3 months of appointment with the County of Register of Wills where the estate was opened. Then the first and final account, this is the formal accounting of the estate, shows what's gone in, what's gone out. So it details all the estate assets, the debts paid, the income that was earned, and proposed distributions. And this must be approved by the court before any beneficiaries receive their final inheritance and the executor is discharged. And then lastly, depending on how long it's taking to administer the estate, a status report may need to be filed. It informs the orphans court whether an estate is fully settled. This is usually around 1 year's time frame from when the executor was appointed, but it's to prevent estates from being left open indefinitely and avoid court-mandated hearings or sanctions. So who can be named as an executor? You can name an individual, a family or a friend, like Monica had mentioned, for a power of attorney. You can also name a family or a friend to be an executor of your estate. But you can also name a corporate executor, like a bank. Orrstown Bank Trust Department serves as executor. We currently have a number of open estates that we're settling. You can also name co-executors, which would be an individual and a bank listed together. So benefits of naming a corporate executor, it basically introduces a third party. So it relieves stress on the family. The corporate executor acts fairly and impartially. They have legal obligation to manage the estate in the best interest of the beneficiaries. We're overseen by the Federal Reserve and the state of PA. And we're knowledgeable and competent in estate law, taxation, accounting, real estate, and investments because we do this day in and day out. So probate is kind of a scary word. Even hearing it every day, it's always kind of a scary word in our industry, but it's just a term, and it's the legal process of distributing your estate per your will. Now, you want to evaluate your will and your estate plan on a periodic basis. You know, if life events change on your end, but also legislation and tax code can change, you want to review your will and your full estate plan. And along with that review, you also want to review your non-probate assets. So your non-probate assets, as outlined there and on the next slide, is your life insurance contracts, your retirement accounts, transfer on death accounts, and assets and trusts that pass to beneficiaries other than the estate. So non-probate assets bypass the court process and pass directly to designated beneficiaries by contract. So basically it just speeds up the process that the assets are transferred to who you want it to go to. However, they are still counted as part of your total gross estate for federal and state tax purposes. So to get around some of that, you could create trusts. And the two types of trust are revocable trust and irrevocable trust. Now there's subcategories underneath these two types of trusts, but revocable trusts are created during a grantor's lifetime. So grantor is the one that's creating the trust and actually transferring assets into the trust. It can be changed anytime while they are living, and it works in coordination with a will. So the benefits of that is that it avoids the state probate process that I mentioned, and it ensures assets are kept private and not a matter of public record. And then for irrevocable trusts, these are created during a grantor's lifetime or at their death. Now, an irrevocable trust created via a will is called a testamentary trust. It's established only after you pass away, and its terms are fixed in your will. They cannot be changed or revoked without permission from the court. They may contain specific restrictions for access and use of assets, and it's the only way to permanently remove assets from an estate because you are giving up ownership and control of those assets and moving them into a separate entity. So the benefits of an irrevocable trust is care for and protect assets for a child with special needs. And it mitigates concerns about heirs not being able to handle effectively their financial inherited assets. So we kind of talked about that with the special needs and the spendthrift. And it also protects assets from a divorced spouse or a beneficiary's creditors. And it can also take advantage of generational tax planning opportunities. As I mentioned, it removes assets from an estate. And with that, speaking of generational tax planning opportunities, I'm going to hand it off to Monica to talk about taxation a little more in depth.
Okay. So while we all will pass away at some point, we don't necessarily have to pay taxes if we plan properly. We might have to pay some, but we can control some of that taxation a little bit better if we spend time now planning for the tax part. So this is the PA inheritance tax. Each state is different. This is for Pennsylvania only. I will say there is a reason why some of the older population tend to move to Florida, and that is because there is no inheritance tax in the state of Florida and some other states as well. But here in PA, unless you are a spouse or a charity that is receiving the assets for the most part, there will be a tax of some sort. So if it is going to our direct descendants, so think children, grandchildren, if you're younger and you're passing it on to parents or grandparents, it's at 4.5%. If you were to pass it to your siblings, you'll be taxed at 12%. And if it goes to anybody else, any other heirs, it will be 15%. So 15% out of full estate can be a decent amount of money going to Uncle Sam. So here's where we want to try and make sure that we're working all the right things that we can to try and minimize those taxes. I will say that we have settled some estates in the past where there were partners or a couple that were not married. The unfortunate side of that is that a person is now, you're going to pay 15% in PA inheritance tax versus 0%. So everybody has their reasons why they do or don't get married. But from a tax standpoint, it would suggest to get married here so that you're not taxed at all on that estate at the time of passing. And then also to make sure that if you're not going to get married, at least that person is listed in the will, or you could end up with some messy court cases fighting over assets. So just a little advice there in terms of PA inheritance tax. When we go to the federal estate tax level, it's a little bit different. So every individual has up to 15 million in the federal estate tax exemption. Andy mentioned this earlier. He mentioned the portability when you've got spouses. So essentially they get combined. So you can almost look at that as a $30 million exemption between spouses. Anything over this exemption level, though, is then taxed at a 40% estate tax value. So it's very high. 15 million sounds large today, but it wasn't that long ago. This was only at 5 million. And so for a couple, many people were still filing estate taxes and paying taxes because it was lower. So all this could take is the act of Congress to adjust this 15 million. So we want to make sure that we're continually reviewing our estate plans and making sure that, nothing from a tax standpoint has changed that would impact our overall plan there. So most people aren't going to be paying a federal tax. But one thing we can do to begin to kind of mitigate some of that tax, or just in general, because you want to gift to your heirs now, is there is this gift exclusion as well. So on an annual basis, you can gift $19,000 to any individual and not have to report that on your taxes. Now, the second you go over the $19,000, you will have to file an additional form at the time you do your taxes. There is a lifetime limit to this. Again, it's that 15 million, and we do look at those as combined, both the federal estate exemption and the gift tax. It is a unified credit or unified exclusion that we need to combine. But for most people, if they're gifting 19,000 per person a year, we don't have to worry about it. It kind of scoots under the radar. So let's say you have a child and they're married, you could technically give them 38,000 because you could give 19,000 to your child and to their spouse every year. So it removes assets from your estate, gifting it to them while you're still alive. The other thing that you can do here, it's unlimited gifting for tuition and many medical expenses. What I would recommend here, though, is that you do pay it directly rather than gifting it to, let's say, to your child, who then pays the tuition or pays the medical expenses. It's cleaner if you make the payments directly. But that will be something that hopefully you don't have to deal with from the medical standpoint. Now, we covered a lot here today, especially all the things that Andy went through when we talked about probate and settling the actual estate and naming the executor. What I will note here is that it's typically a team of people who are helping you prepare for estate settlement. Financial advisors often act as the quarterback, but you need to make sure that we've got an attorney on board who is preparing all those legal documents that we talked about, the power of attorneys, and the wills, the living will, and the last will and testament. If you have a rather large estate, certainly make sure that we have a tax accountant involved that helps us with tax efficiency in the estate plan. And then if any trusts are involved or a plan to be involved, trustees as well. So it is a team effort to get estate planning created and then actually settling the estates in the end. So we covered a lot, but here's just a few takeaways for you to begin thinking about. If this is the first time you're really thinking about estate planning, go through and determine the who, what, when, and how. Take inventory of your assets, debts, and documents. Determine who your executors are in POAs and make sure that they want to be your executor in POA. So have conversations with those individuals. Make sure you have a will, and then plan in place to minimize taxes and any legal complications so that your heirs don't have to. As always, we are here to help. Want to plan early, plan often, and you don't have to do it alone. Again, here are some of our wealth management services: financial planning, investment management, tax advice, and estate planning are all things that we can help our clients with and certainly can help you as well. So this wraps up our 4-part series. However, there is the bonus series we don't want you to forget about, global scams. So everything that clients should know in 2026. This is certainly an important one as scams are out there constantly. So this is going to be on June 18th at noon, led by our fraud and security team. They put on a wonderful webinar. I highly recommend that. And I don't think we have any questions, Chris, unless you see some, but I think that should be it. We will send out the deck. If you have any follow-up questions, feel free to email us and we'll get back to you. Thank you.